Any mention?
Please, Lordship. I'd like to mention item number 7 of the hearing list. These are the cantonment matters. I'm appearing in item number 7, and Mr. P. Nongri is appearing in item number 6, my lord. But he's in bereavement as well. I had a word with him this morning. Your Lordship will kindly take this up after 2 weeks.
It's all right. What about the...
That is still pending with the state government, my lord.
Just say item 6 and 7. That the request made on behalf of the petitioner and not objected to by the Learned Counsel of the respondents. This is a matter of 2 weeks.
2 weeks, my lord. Obliged.
Lordship, I beg to mention item number 15, Lordship. I'm praying 2 weeks' time, Lordship.
Yes. What is this matter about?
Quashing of the FI, Lordship.
Any private respondent here?
Yes, Lordship.
You are supporting the case of the petitioner or you are opposing? You are supporting the case of the petitioner or you are opposing? There is a compromise.
Yes, Lordship.
Kidnapping case, Your Lordship.
Kidnapping case.
Yes, Lordship.
That has been compromised.
Yes, Lordship.
Okay. The request of the petitioner. No one is having. We are having no objection.
No objection, Your Lordship.
Say the request of the petitioner. Disturb it. Yes. Yes.
Obliged,
Much
Lordship.
obliged, Lordship.
Similar prayer for item number 19, Lordship. Here also I'm praying for 2 weeks' time, Lordship.
No objection. Yes. There is also same order. Request of the petitioner. Disturb it. Yes.
Obliged, Lordship.
Please, Your Lordship.
Yes.
I'd like to mention item number 9 of the hearing list.
Yes.
I'm seeking a week's time, my lord.
No objection, Your Lordship.
Obliged.
Yes.
Your Lordship, I beg to mention item number 8. Kindly let this matter come after 2 weeks, Your Lordship.
No objection. As the prayer of the petitioner not objected to by the learned GA in the respondents, this is after 2 weeks.
Your Honor, I beg to mention item number 4 and 5. 4 and 5.
4 and 5.
As for the petitioner, Lordship has heard the matter at length and finally directed state to file an affidavit. We have received and we have gone through, my lord. Spending for quite some time.
Private respond.
Mr. Nath. My esteemed colleague is mentioning on behalf of Mr. Nath.
So you have no objection?
My lord, if the matter taken up next week, subject to Lordship convenience. It's pending for quite a long time. Other Lordship has heard the matter at length. We just
when we heard the matter, it's not there. Probably it was heard long time back. Then entire thing becomes useless if it is.
I am for the state response.
No objection. Yes, when do you want it?
For 2 weeks.
Just say the request made on behalf of the respondent number so and so. Not objected to by the learned senior counsel for the petitioner. This is matter after 2 weeks. Yes.
Lordship, I beg to mention item number 18, Lordship. Lordship, in this matter, the arguing counsel, Mr. S. Walang, is due to some personal difficulty, is not able to appear today, Your Lordship.
That is the matter which was
heard matter, Your Lordship. Only 1 week time, Your Lordship.
Just at the request made on behalf of Mr. S. Walang, the learned arguing counsel for the appellant. And not objected by Mr. K. Learned senior BP for the state. List this matter after a week. Yes.
Highly obliged, Lordship.
Please, Lordship.
So I'd like to make mention item 16, Lordship, on behalf of Ms. Arda Tai, Lordship, Legal Aid Counsel. 2 weeks time, Lordship. Granted.
Any objection? No. The request made on behalf of Ms. Arda Tai, Legal Aid Counsel, the petitioner. Listen that after. Yes.
Item number 1.
May we please, Your Lordship. Your Lordship, in this case, the paper books have been filed. I pray that this matter may be come up for hearing, Your Lordship, after a week.
I have received the paper book, Lordship. Okay. I have received. Let it be after 1 week.
Okay. Now it is submitted by the Learned Counsel. Here the parties. Paper book is ready. We submit with the Learned Counsel for the petition that the paper has been made ready and is already submitted to the registry with a copy, with an advance copy to the learned edition preparing for the state. Stop. How to submit when the matter is now ready for hearing. Stop. Let's wait for list after 1 week.
After 1 week, Lordship. Highly obliged.
For hearing.
Obliged, Lordship.
Item number 2.
Yes. No objection has been filed.
But my instruction that we leave to the discussion of the Lordship, my lord. The delay of 44 days. It's a delay of 44 days, my lord.
Yes, but then all along you have been asking for time.
My lord, yesterday I took instruction.
So you will not have any objection.
Discussion of the Lordship.
I've just come on behalf of Ms. Nongri. So
She's not available.
she's actually had some emergency, that's why I had to come in. Only for today, Lordship.
The request made on behalf of the petitioner. This is not after 1 week.
Lordship.
Yes.
Item number 3.
So nobody is appearing for the
No one, Your
respondent.
Lordship. No
So
one
what
is
is to be done?
Your Lordship, let it proceed, Your Lordship, and keep this matter for hearing.
Let's proceed for hearing.
Yes, Your Lordship.
MS Khanzai, Learned Counsel is present on behalf of the petitioner. None appears for the respondent. As prayed for. This is prayed for by the Learned Counsel for the petitioner. This is matter for hearing after 2 weeks.
Yes, Your Lordship. Much obliged, Your Lordship.
Hearing item number 10.
Where is he?
My lord, this matter relates to seeking quashing of the proceedings.
Yes.
The last order passed by this court, my lord, on the 4/11/2024, Lordship directed the learned chair to produce the case diary, because extensively we have done the argument with regard to 2 petitions. And
It
Lordship,
appears that all the matters are heard by this court. But then the court doesn't remember anything. What is the order?
my lord, order dated 4/11/2024. If the city say, my lord, I pray matter may be proceeded.
Case ready.
Yes.
That is ready with you, Mr. Like case ready is ready with you.
If I have the case diary with me also.
What for we needed case ready?
Lordship, in fact, was pleased to call to see.
Can you go into all those materials at the time of
Lordship,
quoting?
because charge sheet has been filed, Lordship.
A charge sheet has been filed and the trial, I believe, is pending or going on.
What is the stage of the trial now?
Lordship, that is for the.
My lord, the trial is going on.
What is the stage?
Stage, my lord, that particular stage, I don't have that instruction. But the last occasion
We should not exercise jurisdiction in a disposed of matter.
No.
How do you know that
My lord,
that
it
has
is not
been
disposed.
issued? Has the charge been framed?
A charge has been framed.
When charge was framed?
Charge has been framed, my lord. Even charge sheet has been, my lord. We have annexed the charge sheets.
No, charge.
But
Whether
the date of
charge has been
framing
framed
charge,
by
my
the
lord.
court.
My lord, that particular
What is it?
date of framing charge by the trial court, my lord. I'm not aware of that one. But admittedly,
No, but then
trial
we
is
must,
pending.
we must know, we should not, see, this court would not like to exercise jurisdiction in a matter without knowing that whether it's really pending or not.
It is pending. And this
Tell
it is
us,
pending.
tell us when this charge was framed in this matter. And what is the stage of pendency?
My lord, if I recollect properly, the trial is it is about to commence only. It is initial stage of the trial.
What is that stage?
It is initial stage of the trial.
What if you say initial stage? There are many stages in initial. What are the stages?
My lord, the parties are not, witnesses are yet to summon. Cross-examination not yet done. But it will take a long.
Summoning of witness comes after a charge is framed, isn't it? So whether charge has been framed or not.
But charge.
Was there any argument before charge?
My lord, that was done already.
That was done.
That was
and
done.
it was rejected.
Perhaps, my lord, because of trial started.
These are all vital information. Why you are?
My lord, if lordship decide to.
Guesswork. You tell us whether, if you say that this argument before charge was made and that was rejected, and then thereafter also, why should we go for quashing?
But that we will satisfy.
Challenge that order.
My man, we will satisfy. Last, in the last occasion, therefore.
There is a manner of proceeding.
Lordship,
The question is not of satisfying.
lordship, in the last occasion, lordship recollect, we thoroughly argued the case. Lordship has perused the FIR, the charge sheets, the statements of the interested party, and lordship prima facie came to a conclusion from the opinion that it seems there is no prima facie to proceed the
This
proceeding.
doesn't remember.
Therefore,
saying,
lordship,
Mr. Sangrejo,
lordship direct the
probably that
EG to
hearing has taken quite some time back. As you have shown us, this order was passed last year. Okay, at least 2-3 months back.
Yes.
Now, the thing is that you say that this argument was made before charge. That is what your submission is. Then what is the order of the trial court on that? That court will definitely like to see it.
Well, if your lordship decided, I'll produce it by next week.
No, that will be required. So supposing if charge is framed there, then we must know on what basis. There must be some materials. And you are not challenging that that thing, order of framing of charges by the court.
But that is
you
not
challenging it?
part of the proceeding.
Is it required to be challenged?
My lord,
You may say that we are in a quashing procedure.
my lord, my humble submission is even the charge framed by trial court would be solely on the basis of the charge sheet filed by the prosecution. On that basis, my lord,
See,
trial is a.
definitely that will be.
They
But
cannot
then
take additional
even if charge is framed by the trial court after hearing you, then we must see what is there.
But I can produce those.
Mr. Shule, any information about the
Lordship, I have the information till 19/11/2024, Your Lordship.
yes.
So, as on this date, Your Lordship, a hearing argument on charge, whether it has been done or not, I don't think. Let me have.
The senior counsel has made a submission that it was argued, and then when charge has been framed.
Let me have
the last order.
If charge has not been framed, then why should we proceed there?
Lordship, allow
the
me.
last
I'll have the.
There
I'll
is a
check
inform-
from the CIS, Your Lordship. What are the?
Yes, a simple instruction is needed. It should not be something like that, that we find the trial court has declined to frame any charge, discharge them,
Then
and we
decide them.
quash
The
it.
matter ends there.
And we quash.
The matter ends there.
We should not face that situation. The court must be.
Let it come after 10
Because
days, Your
your
Lordship.
submission
I'll
and senior
have all this.
counsel's submission doesn't tell you.
Let the matter be taken up after 10 days, Your Lordship. We'll have all this information.
Well, as per the last order, 21st January,
Yes.
it says as CR put up to the accused persons and such is absent along with the defense counsel. Accused person and such present in the court today. Matter is fixed for APP appearance and CC. that no fresh APP has been deputed in this instant case. The CC cannot be conducted today due to absence of the learned APP. Inform the PP to depute a fresh APP in the instant case. Also issue summon to the accused person for moment to appear on the next date fixed on 18 March 2025.
After January, it has gone to 18 March.
18 March.
Now you say it is fixed for order says it is fixed for CC.
CC.
And you say that this
well,
argument
that
was done.
That
charge was framed.
Well, that was a wrong instrument.
So that, at least
so
we do not expect senior counsel
well,
giving submission without verifying these.
That was incorrect to record, but the record has shown differently. We got the impression that charge has been framed and method proceeded. But it seems the order said it in the CC stage.
And the accused is also not appearing before the
one particular date he did not appear. He is supposed to appear.
Date.
Yes, 2 accused persons appear out of 3.
How many petitioners are here?
3 petitions are here.
Then we can proceed with the matter then.
Yes.
Where is the charge sheet? Charge sheet has been placed before this court.
Yes.
Earlier.
But the charge sheet is page number.
Oh, this case was filed after charge sheet was filed.
Yes. After charge sheet.
After charge sheet.
After charge sheet.
Yes. All right, please.
Page number 73.
Yes. Yes.
The operative portion, my lord, I'll come to page number 80.
Page number 80.
80.
Yes.
My lord. Well, the prosecution of the case is that 094/21 received a written FIR from such education officer to the fact that the director of inquiry such has inquired into allegation and submitted a preliminary report on such, which states that the fact have recorded the statement prima facie case seems to exist against the incumbent principal cum secretary Sri Islam Chaudhary such.
Who are you?
My lord,
What
he
is
is also
your name?
here petitioner. Apu is also one of the petitioner.
No,
he is also the teacher.
Chaudhary or what?
Chaudhary is the principal, who is the petitioner number 3.
No, you are right now here.
We are in the my lord, petition number 57.
What is your name?
Name, my lord. His name is not mentioned in the charge sheet also.
You are not in charge sheet.
My lord,
And what do you
at the
do?
bottom it is mentioned in the last paragraph.
What do you do? What is
He is a teacher. He is one of the teachers in the same school.
teaching in
Teaching in the political science.
that Garudubi High School?
Yes.
He is a teacher in Garudubi.
He's a teacher.
Okay.
He's a teacher.
Anyway, please.
The incumbent has committed criminal breach of trust, misappropriation, and cheating by misusing government funds, which was meant for teachers' salaries for his own benefit. Therefore, in view of facts submitted in preliminary report of the Director Inquiry Wing and as directed by the Honorable Justice and such, Chairman Nogayagda, Shillong for committing crime with cheating and misusing the government fund, the Principal cum Secretary such, Karutubi High Central School be registered, investigated for the prosecution in accordance with law, hence the case. During the course of investigation, visited the PO statements of the affected teachers, assistant lecturers. Complainant were recorded in due course of investigation. Statement of the complainant who filed a complaint with Lord statement representative. Statement from a former Deputy Commissioner of Karo Hills. Statement who filed RTI also recorded during the course of investigation. During the course of investigation, the statement of the then PTO Silsila block also recorded. Further, during course of investigation, certain documents were seized on being produced by the complainant, the case, and affected teachers and assistant teachers. Alleged accused Sri Islam Chaudhary was arrested and forwarded to the Honorable Court and sent to judicial custody. After getting the approval from the Honorable Court, the alleged accused person was interrogated inside the jail premises, and during the course of investigation, alleged person was not cooperating and did not give answers to the questions which were asked him. Notices were served on Apu Hanif Chaudhary. He is a petitioner, and Jim Oman, he is also petitioner, retired TSO, Tura, appearing at OP, their statement also recorded. In due course of investigation from the statement of aggrieved teachers, former TSOs, the then Deputy Commissioner, the then PTO, such, complaining to Logda such, teacher representatives, and from the exhibit seized during the course of investigation, found as well established for misappropriation, breach of trust, and cheating. Based on their above facts and circumstances, a prima facie case is found well established against all the accused persons, Sri Islam Chaudhary, Mr. Abu Harab Chaudhary, and Mr. Mobina Dasan. Therefore,
this concerns misappropriation.
Misappropriation.
Misappropriation of what?
But this is misappropriation of the government fund. Amount also not mentioned. I'll come to that point with regard to number 3. Amount not mentioned. Now, Lordship can see the material, entire materials of the charge sheets. There is no accusation against the petitioner, Mr. Abu Hanif.
No, but then
now he says, now in view of this, he becomes one of the star accused. Now, if I take my lord to the FIR and the report given by the Director of Inquiry, my lord, the previous page, it will be more clear. The foundation of these charge sheets.
Previous page.
But,
page?
My lord, the page number 21 is the petition filed by the complainant before the Lokayukta. Page number 21.
Page 21.
21.
Yes.
My lord, from page number 21.
That is like a petition.
It's a petition before the law.
Before this thing. Yes, right.
And start from page number 22.
So, who is the complainant?
Complaining is, my lord, here, Mr. Abdul Salam.
Who is he? Who is he?
My lord, he said that he is one of the person in the locality. And
is he a party in this case?
We will implement him as a party also.
Are you appearing? Yes.
It started from page number 22, para 1-2, my lord, till the end, para 23.
So this is basically the complaint basing on which the Lokayukta pass an order for an investigation by the appropriate authority, isn't it?
Yes.
Now, what would be the relevance of this complaint until unless this is not been found out by the investigating authority?
Yes. Therefore, this complaint petition contains 23 paragraphs.
Yes.
All the 23 paragraphs, there is no adverse statement against the petitioner, Mr. Abu.
In this case?
Yes. And only prayer was made.
You are Abu Hanif Chaudhary?
Yes.
Just a minute, please. So, charge sheet as well as the complaint before so and so, there is nothing against the?
Nothing against.
Against the petitioner.
Only directed against the principal, Mr. Islam Chaudhary. Only prayer, page number 31, in that petition before Lokayukta. A prayer was made to direct for inquiry against me.
What is the allegation in this complaint petition? Where is the gist of
misappropriation? Misappropriation of the fund.
Where is that part? In which paragraph? Which paragraph? We just want to see the nature of allegation.
Yes.
No, but then you are a party to this, isn't it?
Yes, I was implicated. No notice was served to the petitioner, the present petitioner. However, Lokayukta proceeded the matter, directed for inquiry. Inquiry submitted.
You did not appear before the Lokayukta.
They didn't receive the notice. Now, my lord.
None None of those parties, private parties, appeared before Lokaik. No. Yes.
My lord, kindly see page number 28. And that's a para 4.
Yes.
Is the principal Mr. Chaudhary should be refunded his misappropriated amount.
You are reading paragraph?
It's a paragraph 4 in the middle, my lord. Page 28. My lord. Mr. Chaudhary should be refunded his misappropriated amount for which he has drawn double salary and the salary drawn in the name of someone Islam, a course teacher. So primarily, my lord, that complaint is directed against Mr. Chaudhary that he has a withdrawn double salary amount in misappropriation of fund. They did not specify what amount.
This Islam Chaudhary, he was the principal.
He was the principal.
Was there a managing committee?
Managing committee also there.
And what was position he was holding in the managing committee?
He's a secretary.
He's the secretary.
Secretary.
And what was your status in the managing committee? You were there part of the managing committee?
Yeah, my lord.
The petitioner, this petitioner.
The present petitioner. He's not part of the managing committee. He's only a teacher.
Okay.
He's only a teacher.
He's not even a teacher's representative in the managing committee. Okay.
And my lord may kindly see page number 31, the prayer portion.
Page 31.
31.
Yes.
Only in the middle, my lord, thereby misappropriate the amount by money by the respondent number 1, principal secretary, along with respondent number 2. 2 is the present petition, Mr. Up. 3 is the retired DSS. And managing committee members who are involved in the misappropriation of salary.
This is inquiry in regard to the withdrawal of double salary.
Yes.
But the respondent number 1 is principal in secondary school section and assistant lecturer in higher secondary section.
Yes.
And withdrawal of salary in the name of ghost assistant lecturer. Paid salary to the teachers less than the sanctioned amount. Thereby misappropriated the money who is respondent number 2 and 3. Now, why respondent number 2 and 3 has been the same?
That is why. Nothing is said in the entire complaint against me. Only make a prayer for this. On that basis, inquiry was directed.
So your name was dragged without having any materials.
No materials.
Rather, without having any sort of allegations against you.
But a vague allegation.
Yes.
A vague allegation. But now thereafter, what happened? The inquiry, after inquiry, the report. The report is available, page number 65. Report submitted by the director. Inquiry. Page number 65. Is in person to the direction given by Lord Webster.
This is a submission of preliminary inquiry.
Yes.
Yes.
Now, the relevant portion. My lord, page number 67. Those so-called affected teachers who are deprived of their salary, they have already filed a writ petition also and pending before this honorable court.
It's still pending?
It's still pending. In fact, the audit of these teachers were...
In the writ petition, what is the fee raised?
In the writ petition, they were dismissed. Dismissed from service.
Okay. So that is not against specifically against non-payment of salary.
Yes. Primarily, but they take up that plea also. That they are deprived of the salary, and instead of paying salary, they dismiss. They were dismissed.
Not specifically confined to the point, the complaint which has been raised here.
But it is a similar plea. It is a similar contention. Similar contention. Now, those audits, those so-called misappropriated amount, audit was done by the government. Auditors has cleared the audits. There is no misappropriation. And despite of that, they filed a petition is pending.
This preliminary investigation report, what do you want to point
now,
out?
my lord, I'll come. Page number 68. 60.
Yes.
But having recorded the statement as prima facie
Conclusion.
case,
Conclusion.
my conclusion
Yes.
seems to exist against the incumbent principal, Mr. Chaudhary. Reference also be made to all the available documents as well as the statement of agreed persons. At this stage, it is difficult to find out the actual amount that has been received as grant in aid from the government. After proper verification of documents and investigation, the actual alleged misappropriated amount will be honored. In my view, regular case should be registered at the local police station. FIR should be filed by the concerned education department to get into the bottom of the case. The incumbent principal has committed criminal breach of trust, misappropriation and cheating by misusing funds for his own personal benefits.
That is specifically against the principal.
Against the principal. Nothing against me.
Yes.
Now this is a report. On that basis, my lord, now.
That is the preliminary investigation.
Preliminary investigation. And my lord, we came to come to page 70, the final order passed by the Lok Yagda.
Yes.
Page 70.
Yes.
The Lok Yagda has recorded the concluding part of the report. And just below that, my lord, having considered a opposing inquiry report, it is directed the district education officer to lodge an FIR at the police station, which should be registered, investigated for the prosecution in accordance with law. Respondent should be brought to book immediately if so warranted during investigation. The SP of Tura shall monitor the criminal prosecution and submit status report within 50 days from the date of receipt of this order. Now the respondent, who is the respondent? Respondent number 1, Mr. Chaudhary. So Lok Yagda, in its wisdom, directed the police department to launch a prosecution against the Chaudhary.
No, but then why? If you see, the name of respondent, Islam Haq Chaudhary and 3 others.
Yes. Madam, Islam Chaudhary.
And 3 others.
Right.
And the action is sought to be taken in the respondents.
Respondent, madam. The respondent shall be
Not
madam.
against any specific respondent.
Yes.
Anyway, but then what bearing this will have?
No, therefore, because the FIR, no, I'll come to the FIR. The entire FIR is founded on the inquiry report submitted by the director. It is not a normal procedure where the complainant goes to police and lodge a FIR. No.
See, your thing has culminated in submission of charge sheet. Now, charge sheet will definitely prevail over all those things.
Therefore,
these are the reports basing on which the investigation was conducted.
Right.
Now, will it be your case that even if we accept the allegation made in the charge sheet as true, in that case also there no offence will be made against?
That is exactly.
If you have that can make out a case like that,
yes,
then we can.
That is my case.
Otherwise, where is the question?
That is the case. Even, my lord, on the face value of the FIR, read with the charge sheets, assumed to be true, though I dispute, one cannot discern that there is a privacy case against the petitioner for launching a criminal prosecution.
So that is
and the lordship is very clear. If there is no material, my lord, lordship can invoke your jurisdiction.
If there is no allegation,
rather,
whether there is material or not, that will be seen at the time of trial.
Right.
But then whether allegation is there or not,
yes,
that is what is to be seen.
Yeah, right. Therefore, the complaint petition filed by complainant and the local order, along with the report, there is no allegation against me. That is my argument. Now, when we come to FIR, lordship, kindly page number 71 is the FIR.
Yes.
Now, this FIR also, my lord, filed against the Mr. Islam Chaudhary. The last paragraph.
This is 7th April.
My lord.
Yes.
So the present petitioner is not a name accused also. And there no statement material mentioned in the FIR also against the petitioner. Well, for the time, I'm segregating the case of 2 petitioners and the petition number 3.
Yes,
principle.
we can understand that.
Now, my humble submission is that, my lord, there is no material On the face value of the FIR, one, no prudent person can find any incriminating statement, accusation against the petitioner, Mr. R.
Now, this FIR calls for registration of case only against Sri Islam Haq Chaudhary,
Yes.
isn't it?
Yes.
That isn't specifically mentioned. That is what the meaning of that
Response.
subpara
Yes.
conveys. Though
Yeah.
it is written in something is missing in this, but then it speaks about registration of case
Yes.
against Islam Haq Chaudhary.
Yes.
Yes.
In the Lokayukta orders a respondent. That respondent is Mr. Chaudhary.
So when there was no allegation against you in the FIR, where is the question of question of prosecution dragging you? That too without any materials. Now, whether the charge sheet comes with any supporting materials?
Nothing. Therefore, Lordship,
apart from what has been reflected as a prosecution story, what are the materials based on which charge sheet is sought to be put?
there is nothing as such.
There is nothing, no
Nothing as
enclosure
such.
in the charge sheet.
Madam, therefore,
Doesn't say about documents or
yes,
witnesses or nothing.
But he is only a teacher. He is not a member of managing committee.
The problem is here is that the statement of the statement of the witnesses, Your Lordship, who which the charge have not been enclosed also, Your Lordship.
Let us
So some parts of the things are missing here. So have you collected those details? You can collect those details.
I do have, Your Lordship.
You have. So then it's okay if it is a part of charge sheet. So Mr. Shangaresha, you should have basically enclosed the entire charge sheet then.
But that was
Since
not.
you are seeking quashing of the there.
That was not made available to the petitioner
No,
by
then,
filing.
you should have.
Filing.
That becomes, and you should have asked for those copies. You should have
Sir,
pointed it
on the
out.
face of the charge sheets, my lord.
By suppressing
Page number
those.
80. No, it is not a question of separation, my lord.
Those are not.
It is not prohibited to the petitioner.
At least, see, at least you must be aware that this charge sheet contains the name of some witnesses, may have
Well,
some.
all details are there. Those
this
details.
court had asked you questions, but then you said that there is nothing as such.
Lordship, kindly see.
You did not even say that these things are pointed. Only after Mr. Shulai is pointing
Kindly
out.
see,
then
Your
you
Lordship,
say.
the case has been fixed for constitution of the charge, Your Lordship. The copies
Page
have been
number
supplied
71,
to, the
78,
copies have been
78.
supplied to them. They should have filed by an additional affidavit to bring on record those statement, Your Lordship.
Page number 78, man. List of witnesses. All those
Then it's
details.
okay, but then what are
The statement of those people are very vital, Your Lordship.
what are the documents seized here? How many documents were seized in the course of
Nothing is from the petitioner here.
That will find at page
But-
81 and
81? These are the seizure list. So there are many documents also.
Yes.
Sir, Sangresh, you are not pointing out all those things. The
No,
court
no.
had asked you all those questions.
It hasn't ceased from the petitioner. All documents are seized from different persons. And he is not aware of
There is
those
no
documents.
question of making seizure from you. We have to see whether those document has any connection with you or not. Whether you prepared any document or not. These are all things will be vital.
A charge sheet has been filed.
To establish a charge against you, there is no requirement that this document will have to be seized from you. It can be any other
But
official
any
document.
documents adverse to me, my lord, I am ready to face
This,
it. my lord.
how many statement of how many witnesses are there in the charge sheet? You please bring on record those. There are the number of witnesses. No statement recorded under 161.
No, they are, Your Lordship. They are.
Not included.
but it has not been approved.
Particulars of
witness to be examined.
Can you look at those statement at the quashing, Mr. Shulai?
That is one aspect.
Lordship, these
Exactly.
are part
What
of-
is the position of law?
Lordship, kindly see the statement made, Your Lordship. It is on the basis of the statement made, Your Lordship, that a charge sheet has been filed.
No, that is okay. But then what is there any law regulating that part of the thing? Any decision?
So far, decision
Because if we go by the stipulations in the Bhajanlal's case,
only a
doesn't say
prima
anything.
facie, only a prima facie case.
It only is saying that you confine to the complaint or
content
the
of the
charge sheet and all
FIR.
that.
But now, Your Lordship, now a charge sheet has been laid, Your Lordship. A charge sheet has been laid, Your Lordship. So Your Lordship will have to see whether prima facie material are there or not to proceed.
Exactly. So that is the thing. So say supposing if by plain reading of the charge sheet, if you do not get anything direct against the petitioner here, to basically confirm whether there really exists any part paid by him or not, whether there exists any allegation against him or not, can we look at the statement made under 161?
Lordship, because as I have submitted, the Lordship, the statement made under 161 CRPC, Your Lordship, is a part of the charge sheet. That is also from part and parcel of the charge sheet. Because if they face a trial, they have going back to 207 CRPC, those copies should be given to them, Your Lordship, so that they will confront.
Then you bring out record those statements.
And there are certain decisions of the Honorable Court, Your Lordship, when a charge has been filed, so let the trial court take a call. And that also I'll place, Your Lordship, all those decisions.
But then if you have those hold these statements with you, you cannot place it before us. Of course, it is not your duty.
Lordship, he has come for quashing, so the burden lies heavily on the petitioner, Your Lordship.
Can we skip that looking at 161 statement? What is law? If we can show that is perusal of the statement is not necessary, then we will proceed. But then, as Mr. Shulai says, if this 161 is a part of the charge sheet, then we may have to look. And then to establish your case, then probably you should furnish us all the total set of the charge sheet.
My humble submission would be to launch a criminal prosecution. The quality of the allegation in the charge sheets is the foundation. My lord,
but then how do we judge this?
My lord, the quality of accusation in the charge sheets is based on the certain materials and investigation statements. Definitely, it doesn't come by its own. It comes with the supporting materials now. Now, my lord, if there is some important accusation is missing in the charge sheets, the law is open to the prosecution to file additional charge sheets. Law is very clear. Otherwise, launching a prosecution against a citizen without framing a charge, disclosing the charge, accusation, is absolutely untenable. It's how they are doing.
No, you see, if you see the last part of the charge sheet, there's a reflection of your name, and section 34 has been incorporated. Isn't it?
Well,
along with 403, 409, 420,
yes.
34 is there. Now, basically to see whether at all you had played a role or not, can you look to prima facie see whether you have played any role or not? Can you look at 161 statement?
My lord, my lord, this honorable court would not go for detailed inquiry. What is behind? What is behind the
See,
charges?
we say the prima facie. Now, whether the statement is correct or not, we are not going into it. Now, if you go into that area, that is barred for us. We cannot go. That we understand. But then to see whether prima facie there is a role played by you or not, just to ensure it, can we see at the statement made under 161? Look at the statement made under 161.
Lordship can.
So there is no dispute.
But Lordship can look
We
into.
would like to see those. If you say if there is no bar, then we would like to see.
Well, the last occasion also, therefore, Lordship directed for protection of the related case diary for that purpose. Lordship, we have reached the same destination earlier also.
Case diary may not be for the purpose of 161. 161 is not prohibited. Case diary is for other things. This should have been basically something else. Actually, I do not know what made this court to pass this order. Okay.
If Lordship wants to peruse it, Lordship can. We'll place a decision, my Lord. If nothing is there in the charge sheets, my Lord, Lordship has enough.
But then if you say
power
charge
to quash
sheet,
it.
161 statement is a part of charge sheet, then definitely without seeing that, how can we say that there nothing is there?
But I did say nothing. My Lord, therefore, therefore, the charge sheets, my Lord, the charge sheet is the foundation. They cannot say that no, the hundreds of documents are there.
The foundation, all right. But then if you say that statement is a part of the charge sheet, then that also becomes a part of our foundation.
My Lord, therefore, my humble submission is that if they want to launch a prosecution, my Lord, that needs to be, my Lord, whatever missing, whatever why the accusation is mentioned in the 164 statement,
Mr.
and not
Sandeshu,
reflected in the.
As we can understand from the order of the trial court which he read out before us,
Yes.
that is pending for consideration of charges.
Yes, it's.
So that means that there is already compliance of section 207 so far as the supply of copies are concerned. So how can you be ready for CC without getting a copy of the statement? The statement should have been there.
But the statement and the force.
161 statement.
My Lord, whether that copy might have provided to him or not.
But then
After,
he
perhaps
say
they
the
provided
trial court-
after
trial
filing a
court-
petition.
Trial court, before trial court, it's pending for CC. Then?
Yes, yes.
There is assume that you have been supplied with the copies. Until and unless you specifically deny.
It cannot
Well, that might matter.
And then
They
if
should-
you have
they-
got
they-
it, then why it is not there then?
No, perhaps it was supplied after filing the petition. I would bring on record if those things are there.
But then
If
charge
Lordship
sheet,
would like to.
how you got a
peruse.
charge sheet then?
Well,
How you got the charge sheet then? Charge sheet, how you got it?
it is received from the prosecution, no doubt. But whether the matter that charge sheet, the other part of the statements.
See, Mr. Sangreshu, with due respect, there are some inconsistency in your submission. Kindly have the full set of instruction. Because
We
if
will-
certain
we'll
part
bring-
is
we'll
missing,
bring.
you cannot cover it by, you see, applying your own.
No.
So either you say that you have received or you have not received.
But let me
Okay.
let me ascertain that one. If they receive it, we'll bring on record.
Then kindly bring your track out that 161 statement.
If the statements are there,
Yes.
we'll bring it on record.
Yes.
Within a week time, we can bring on record.
So you'll bring it on record by filing an affidavit.
If
Or what?
your Lordship permits me, we can do that.
If you want it, then we'll pass that order. Let Mr. Sulai let him do that.
Lordship, yes, because if we go by 173, Your Lordship, all those part and parcel of the charge sheet.
Okay.
Statement recorded under 161, those are part and parcel of the charge sheet. And in view of section 207 of the CRPC, Your Lordship, the accused is entitled. Denial of all will amount to unfair.
There is no
trial.
dispute. There is no dispute to that.
Lordship, yes.
But then only thing is that, say supposing if he had to peruse the charge sheet, whether we confine only to the prosecution story which has been reflected in
No,
the
Your
charge sheet,
Lordship, in my humble and
or we
respectful
can
submission,
go beyond that by perusing 161
the
statement.
the statement of those of the people who have, whose statement had been taken under 161
Any decision by any high court or with regard to that, whether we can go into that. or
Yes,
not.
Your Lordship, there is one decision of the Honorable Supreme Court, Your Lordship. It says like this. It says like this, Your Lordship. If the petition under section 482 was at the stage of FIR, in that case, the allegation, the FIR complaint only are required to be considered, and whether a cognizable offence is disclosed or not is required to be considered. However, thereafter, when the statement are recorded, the evidence is collected, and the charge sheet is filed after conclusion of the investigation and trial, the matter stand on a different footing.
Okay. So, giving their impression that we can go into this.
And the court is required to consider the material evidence collected during the investigation.
Okay, then that is okay. That is what that suffice. Then you bring it on this thing, Mr. Sambhaji.
164 statement.
Please all the petition.
Yeah, yes. Please, that one, this one, you place it in the later when the matter is.
Lordship, I'll please by
Our learned counsel, learned senior counsel for the petition, and also Mr. and you should not. Mr. So-and-so, London Senior Counsel, assisted by so-and-so, for the petitioner. Mr. Andy Shulai,
along with
AG, appearing with so-and-so, and Mr. Sheikh, London Counsel, appearing for 1-5. Yes. You are paying for?
along with
Okay. You have to just after hearing the parties at some length, it appears that the statement of the witnesses recorded by the investigating authority or during the course of the investigation is required to be placed before this court for better appreciation of the matter. Stop. The petitioner shall bring on record the statement of the witnesses recorded under 161 CRPC, and also any other supporting materials based on which the charge sheet has been prepared, if the same are not already a part of that, by filing an additional affidavit. Just you have to part it, okay? You have to put the comma so that yes. How long will it take?
10 days time, Lordship, from Karwins.
Give a paragraph aspirate for 2 weeks time is granted to the petitioner to enable him to file an additional affidavit, bring on record the above materials, bring on record the materials as indicated above.
same order in 11 and 12.
This will all can be heard together and
Yes, it
decided.
can be heard together.
But
The principal is not a petitioner here in this.
he's a petitioner.
He is a petitioner.
So you are arguing for the same issue.
Yes, yes.
Now,
This was
if
a
you
petition.
take into consideration your submission in this matter, will it not be damaging his case?
No, no. Therefore, I'm segregating, madam. Two of them. One is a
But then
teacher.
how can the same counsel in one case you come and you say that entire allegation is against him?
No, no.
And the second case when you argue for him and you will say there is no allegation.
Madam, I'm not accusing that he's the accused. I'm not supporting the story of the prosecution.
Mr. Shangri, so think over, we do not know. That is for you. You are a professional. Just think over what you will do with. Just same order in those matters also.
We can bring on.
But then please think over. Because this court will definitely have some sort of reservation. You see, you cannot change your stand because you are appealing for the petitioners.
My lord, I'm not. I'll satisfy my lord.
Item number 13.
Yes. Dismiss.
Please, Your Lordship. Lordship, Senior Counsel is leading this matter, Your Lordship. Senior Counsel is leading this matter, Your Lordship.
Yes.
Lordship,
let it come up next week, Lord.
You say something clearly, we cannot hear you.
Bottom of the porch, Your Lordship.
You may not have much matter at the bottom of things.
We'll take it up next week, Lord.
The joint period might be the parties. This is matter. After which. What is the matter about here?
This is again a trial matter.
Quashing. Again quashing here. No,
my lord. He wants to.
Okay.
Item number 14.